For all of you here today, we wanted to first thank you for being in today's webinar. Today's webinar is brought to you by Eisinger Law and Affinity Management Services. Today we'll be going over condominium HOA board meetings, as well as election and board and budget season. But before we get started, I do want to say a special thanks to those that work really behind the scenes to make this happen. I wanted to thank Joshua Eisinger Law and also Ashley. Because of them, we're able to put these kinds of webinars together. So I wanted to thank both teams for all the hard work and effort that you put in to make these happen. So let's get started with some ground rules here. First, obviously what's being done today is there's no legal advice. It's a kind of legal advice disclaimer as to the accuracy of the information. The information contained in this webinar is for information purposes only, and it's not legal advice or a substitute for legal advice. So basically, we're providing our best knowledge of how to deal with these kinds of situations. But if you find yourself that you need specific questions, either reach out to the team here today, or feel free to reach out to your attorney as well. We are gonna open, the webinar we're gonna do our best to try to answer as many questions as possible. We did receive already close to 13 questions. For those of you that didn't have the opportunity to send any questions, feel free to click on the Q&A button as you see here. Dialog box will open and you can feel free to answer your questions. We'll do our best to answer them either live or type them in if either of us have the opportunity to do so during the presentation. We are going to try to keep it within 1 hour to respect everyone's time. As stated earlier, the webinar will be recorded and posted on both organizations' website. Further, if you want to make it to be able to see the webinar a little clearer and also the slides, feel free to click on the view options and you'll see a side-by-side mode, and that'll give you the option to really just put us to the side and focus on the presentation itself. So with further ado, I wanted to introduce the two individuals who I have the pleasure of hosting this webinar with, and I wanted to start with Carolina Scheer. Carolina Scheer is a partner at Eisinger Law, a full-service law firm based in Hollywood, Florida. Ms. Scheer focuses her practice on real estate law, condominium and community association law, commercial litigation, construction litigation, and developer representation. Ms. Scheer is an adjunct professor at Nova Southeastern University, Shepherd Board Law Center teaching condominium law, and also teaches a DBPR-approved condominium and HOA board certification course, and regularly trains and certifies clients on law firm and board members throughout the state. Ms. Scheer brings a significant amount of association litigation experience, representing luxury high-rise condominium associations, concentrating on association-related general representation and construction defect litigation, as well as general commercial and real estate litigation matters, association lien foreclosures, and collection-related litigation. Concentrating in international law, Ms. Scheer earned a dual law degree, receiving her Juris Doctor and graduating summa cum laude from Nova Southeastern University, Shepherd Board Law Center, and the University of Barcelona. That must have been a fun college experience that you had there. She received her Bachelor's of Science, Bachelor of Administration degree, and graduating summa cum laude from the University of South Florida. So with further ado, I want to introduce Carolina, and thank you so much for being here today.
Thank you for having us.
No, my pleasure. Next, we have Alessandra Stallman. Alessandra, her primary area of practice are real estate law, condominium and community association law, commercial litigation, construction litigation, and corporate partnership law. She's a board certified condominium and plan development attorney by the state of Florida. She also teaches DBPR approved condominium and HOA board certification courses and regularly trains and certifies clients on the law firm and board members throughout the state. In addition, she is certified to teach DBPR approved continuing education courses for community association property managers and CAM licenses, and frequently participates in panel speaking events on various community association and real estate topics. So with further ado, I want to introduce Alessandra here today. Thank you for being with us.
Thank you.
And last but not least is myself. I'll keep myself short because really what we're here to do is learn. My name is Rafael Aquino, and I'm the co-founder and CEO of Affinity Management Services. We serve condominium and homeowners associations throughout the Tri-County area. We are an organization that is core focused on working with clients that are looking for a high level of service, as well as being able to have significant high touches from the back office. So I wanted to let the dynamic duo, like I like to call them, to get started. So Alessandra and Carolina, if you can kindly jump in and go over some of the requirements in order to host a condominium annual meeting and election.
Okay, so thank you everyone for being here. We're gonna go over some basic statutory requirements and basic issues for condos and HOAs. And I know we may have some co-op individuals, board members here as well. So we'll try to address that. And you know, we know that it gets a lot more complicated, but in order to talk about the detailed issues, we need to get through these specific statutory requirements. So, you know, I don't want to oversimplify it, but if you're in a condominium, the statute requires that you have to send out a first notice that has to be mailed and delivered 60 days before the scheduled annual election meeting. The candidates have to give their notice of intent to run for the board at least 40 days prior to the scheduled annual election meeting. And then they have the right to submit a candidate information sheet. Assuming they're eligible, and we'll speak about candidate eligibility in a second, they will be put on the ballot, which will be sent out with a second notice that needs to be mailed at least 14 days before the annual meeting. You also need to worry about an organizational meeting. It's usually right after the annual election meeting, and we recommend that you send that notice out along with your second notice. The ballots, where you include the eligible candidates, have to list all of their names in alphabetical order by last name, and you can't indicate which one is a new board member, current board member. You just need to list them in alphabetical order. I think we can go to the next.
All right, this is a very interesting topic. It's candidate eligibility, and there are some documents that will have additional eligibility requirements that may or may not be enforceable. But pursuant to the statute, candidates must be eligible to serve on the board of directors at the time of the deadline for submitting a notice of intent to run in order to have his or her name listed on the ballot. So it's very important that as you are getting ready to embark in your election cycle, that you take a look at your ledgers, make sure that they're all cleaned up, and that you know, whoever is submitting a intent to run for a candidate or intent to run for the board is not delinquent in the payment of any monetary obligation. Likewise, any person who's been suspended or removed by the division is not eligible. Alessandra, you'll agree that in our, you know, combined 20 some odd years of practice, I've never seen that happen.
So I've never seen, ironically, I've never seen anyone be disqualified until, not by the division, but until recently. I did have someone that did not have their civil rights restored as a felon, but the association didn't do their due diligence before putting them on the ballot. And as a result, they were voted onto the board, and then the association had to deal with a vacancy because that individual wasn't eligible to begin with. So that's a really tricky thing to look up because every state has different information online. You may be able to get the judgment where they're convicted of a felony, but it's not so clear when their civil rights have been restored. And the burden, in our opinion, is on the candidate to provide information to show that it's been restored. But it's a really, you know, detailed provision that gets ignored by a lot of associations. You generally only start looking into this if you know from rumors or otherwise, or when board members don't want certain people to be on the board. But it should be something that's done standard, and it should be reviewed before you put their names on the ballot. You need to make sure they're not delinquent and that they are eligible to be a candidate. Oh, go ahead.
Yeah, I wanted to ask you, because I wanted, for some of the board members that are maybe new, with regards to the suspension of, for owners that are delinquent in payment and any monetary obligation, can you kind of go into what the steps the board should do to make sure that those individuals are not included within the ballot process?
Right, so if they're delinquent as of the day that the notice of candidacy is due, they're not eligible. Now, there's a whole other issue with suspension of voting rights of delinquent owners. And that there's a whole other process involved with that. So if you have delinquent owners and you want to suspend their right to vote at a director election or otherwise, you have to go through a process. And the statute was amended not too long ago, which requires that you provide notice of the delinquency at least 30 days prior. And it's unclear what that notice is. And then you have to actually vote at a meeting to suspend the voting rights and notify them of same before their voting rights get suspended. So it's something that the board, if you're going to do, you need to think about this as you're sending out your first notice, how you're going to address it and how to do it timely.
Correct.
However, it's very important to note that the suspension of voting rights may be challenged. Not every association may actually have the right to suspend voting rights. I've litigated this issue. It goes into whether or not an association has Kaufman language, meaning that the ability to suspend voting rights was added to the statute. And if your governing documents were not drafted, were not enacted after the fact, or don't have what's called Kaufman language, a provision that says that any statutory amendments may apply, there is a chance that if you do suspend voting rights, it may be subject to challenge.
Yeah, that's an excellent point.
Another question actually we're getting, and this is something that I tried to look into with a colleague that's a criminal defense attorney, as far as whether the recent voting rights amendment would negate the felon rule. It hasn't been addressed. Like Alessandra said, the issue of restoring civil rights and the issue of determining whether someone's eligible because of that is very nebulous. In all honesty, it's very hard to search and track this down. There's not sufficient communication between the different government agencies that are responsible for having this done. I think it's somewhat unreliable, and if you are looking to do this, you should consult with counsel and proceed with caution.
Two other points. I'm sorry, Raphael. I know you're trying to get us past this.
It's hard to get a word in with us too, and some of our partners will say the same thing about us.
So we got one question via email as to the monetary obligation and what is encompassed there, and as far as monies due to the association eligibility. Generally, that's based on the ledger. So you need to make sure that if you intend to run, you take a look at your ledger, you see what's there, and the association should also be looking at the ledger, because sometimes there's a few cents delinquencies because of different issues or it's not clear. So those ledgers should be looked at frequently, and especially right before an election, so that you don't have any issues as to who owes money and who doesn't. And then we have a question here and it's from John Gordon, who's an election monitor, and he says, I have monitored elections that the board has to make certain to suspend voting rights in their meeting minutes to justify the suspension of voting rights. Can you concur? So as we said, in order to suspend the voting rights, the board not only has to give prior notice, but has to suspend the voting rights at a properly noticed board meeting. So that should be documented in the minutes. So I would agree. I don't know that the minutes would include every individual, but those individuals also have to get written notice after the suspension. So there is a whole process. And when the association goes to an election, whether you're telling the attorney or the election monitor, hey, these units are not entitled to vote, you should provide the backup to show that the voting right was properly suspended. Correct.
Yeah, and you should have your minutes. And also one important point to keep in mind is that if you do suspend those voting rights, that your quorum requirements also will change with that as well. Yeah.
Correct.
Okay, I do have another question here, which I think we kind of go with Olga asked, delinquency notice should be sent 30 days prior to the election or candidate info due. I think she may be a bit confused. Basically, what we're talking is the voting rights. You do have to provide the individual notice, at least 30-day notice, as Alessandra was stating earlier. However, if you receive, let's say, 5 candidate forms, and 2 of those candidates, let's just say, are delinquent at that time, there's no notice that's required. That person will not be included in the ballot process.
Correct.
So I'll let you continue with the presentation.
Okay. So Carolina, do you want to take this?
Sure. We have a few more questions. Let's go back to the slide, and then we'll come back to some of the questions. When the association gives its second notice of election. So we've gone through the process. We sent out the first notice at least 60 days in advance. We have, at the 40-day mark, anyone who desires to be a candidate submits their candidate intent form. Thereafter, at the 35-day mark, they can submit their candidate intent sheet, which is, by the way, not obligated, but encouraged, and the association has no liability for for the content of that candidate information sheet. However, my rule of thumb is, if you wouldn't want your grandmother to read it, don't put it out there for people, because then you have issues. You know, it could get very heated, and you don't want to get yourself into that situation. You want to go ahead and put yourself in the best light possible. Now we get to the second notice, and that must go out at least 14 days in advance of the meeting, but no earlier than the 34-day mark. In that second notice package, in addition to your notice, your agenda of the meeting, you must also include an outer envelope and an inner envelope. And keeping that in mind, this is only for condominium associations. It's also for HOAs that have the quote unquote, the secret ballot or adopted provisions that kind of mirror the condo aspect, and co-op associations. So you have an inner ballot and an outer ballot. Your inner ballot is usually just a small ballot small envelope that will say ballot. Your outer envelope will be a ballot that will usually have the address of the association in the front, not necessarily required, but at the top, generally speaking, at the top right hand or top left hand corner, you'll have the ability to put your unit number and address. I encourage all members to actually spell out their address and be very clear. And if you haven't practiced your handwriting, you will be doing us a huge favor if you print clearly. This isn't just a ministerial act. We need to clearly see who's there. Otherwise, we wreck our brains trying to figure out what those ballots say, as well as printing your name and signature. One of the things or common misconceptions that we have regarding the inner and outer envelope is we often receive outer envelopes, but no inner envelope. And the case law has determined that is that individual unit owner's decision to waive their right to have an anonymous vote. It does not invalidate the ballot. So what we do in those circumstances is we carefully take that ballot, put it down. We want to kind of make sure that everything's kept intact. And I've seen some great election monitors do this, as well as attorneys. We notate how many outer ballots we get, how many inner ballots we get, how many outer envelopes, inner envelopes, how many ballots we get, so that we can keep track of what's being made in case it's requested later. Oh, and last but not least, whenever you send your notices, the association must sign an affidavit of mailing, which must be kept in the official records of the association, certifying that they've gone ahead and issued the notices within the statutory time period.
Correct. And if I wanted to add to that, it's very important even more this year, especially with everything that we have going on with our own country's election, is that you're making sure you're mailing these notices with ample time. There is a process to be able to mail them, and especially, you don't want to wait till the deadline. You definitely want to have that postmark with the minimum of the 60 or the 14-day, whatever your requirements are. I also wanted to touch up on another point with regards to, the use of technology. While Zoom has helped us so much, we can continue to use it even to make your elections a little bit more transparent. So one of the things that we've been trying to recommend our boards that are going to have elections is to actually just have a Zoom meeting where you can introduce the candidates, where the candidates maybe get 4 to 5 minutes to talk a little bit about what they're going to do for the association. And it allows for a little bit more transparency, as well as an understanding of the person that you're potentially going to elect. Obviously, the board has to kind of agree to that, but either way, that's a good way of using the technology to communicate with your residents of what's going on with the potential candidates.
And one comment in the mailing, not only for mailing purposes to comply with the statute, but as I think all of us have experienced, the mail has been really slow. So you want to make sure that you send it with enough time to give the owners the ability to send it back. So just keep that in mind. You may want to send that second notice before the 14 days so that you can get a quorum and actually have your election.
Correct.
The big problem that we have, especially now with COVID, is foreign owners, and how to deal with that, and some delays in the mailing. So I understand it's the 14 days, but we do encourage to try to get these things out as early as possible to try to help with the situation. Otherwise, as we'll be talking a little bit later, for foreign owners, the option of electronic voting might be viable and encouraged to ensure that they have the ability to participate.
Correct.
Okay, so HOA annual meeting and election. HOAs are very different. A lot of it is based on the declaration itself. The statutes defer to the declaration and the bylaws. So the notice requirements depend on what your governing documents provide. There's generally not the two notice, the first notice and second notice as we have in a condo. And if there is no provision in your bylaws, then you have to give at least 14 days in advance of the annual meeting and the election. The interesting thing about HOAs is that the statute requires nominations from the floor unless your governing documents provide for an alternate method. So unless otherwise specified in the governing documents, and governing documents for HOAs are defined to include rules and regulations. So that gets a little bit interesting as to strategies for HOAs during COVID, and we'll talk about that in a second. But your nominations from the floor are permitted and essentially required unless you have a different process. And once you reach the quorum, which is 30% or a lower amount if provided in your bylaws, you have to open it for nominations from the floor. So members in good standing can nominate. Oh, sorry, wait, go back. Okay, so you go through the nominations from the floor. Usually with ballots, you're going to get the nominations and the ballot's going to be blank and you're going to hand them out and someone's going to vote. The other interesting thing with HOA elections is most HOA documents allow members to vote by proxy for directors. That's a big distinction between condo documents where the individual owner has to go through that process to ensure they're the one voting. You can't give your voting right to somebody else. For HOAs, you can. So you get into this proxy battle and people are going around collecting proxies and then they show up at the election and they say, okay, here are my 10 proxies, give me 10 ballots. Yeah. And you have to verify the voting certificate, the proxies, and then make sure you keep track of those ballots. So it gets a little tricky when you have contested HOA elections. Okay.
Okay, condominium elections held via Zoom. So this started in around March 13th, where we found ourselves with the complete inability to have live elections. For condominiums in particular, and we'll address the dilemma with HOAs in the next slides, but we have been able to successfully hold several condominium annual meetings and elections via Zoom. The statute actually was written in a way that we were allowed to do this. When you are preparing your notices, even your first notice, and particularly right now, this is an evolving situation. Early on in the pandemic, we were just saying the meeting's going to be held via Zoom. We gave the information. Now that some restrictions have been lifted, the associations have the choice of providing Zoom or having it provided that their local government permits gatherings of this nature, of having it live. Right now, whenever I do a notice, I basically indicate whatever the board's intent is to, whether it be Zoom only or hybrid or in person. And I have to disclaim it and say, this is subject to change given the current situation. Now, when you are doing a Zoom election, it's very important that on your notices, you want to explain the situation. You want to go ahead and you give them the Zoom ID. You want to give them the access number. Zoom, and there are other platforms as well, but Zoom also gives you ways to call in so that attendees that may not be computer savvy or may not have access to a computer, they can just call in. We also, we found it very beneficial that at the meeting itself, we not only have one camera, but we have several cameras. So what I've found to be very beneficial is I have about 3 laptops in the room. One laptop kind of pans around the entire room just to show the overall comings and goings. And then I usually have 2 counters to keep social distancing. And I've had my 2 counters sit there with laptops. So the membership that wants to watch can see what the counters are doing, and it gives them a little bit more of a reassurance of the process. Because this is, you know, similar to this, if you allow the members to unmute themselves during the counting process, it's just because of the nature of this, it becomes very, very disruptive. So I would say offer the option to have people place comments in the chat or questions in the chat, but don't unmute the situation, and you'll find that the process will be much more streamlined. I'm having trouble with the PowerPoint over here, so I can't see what the last bullet point is. But when you open,
oh, so it says always to provide Zoom procedures, instructions, i.e. how to raise your hand or make a comment, which I think you've already addressed.
Right. And I think what we're going to get to in addition is we've developed a procedure where, in addition to our regular notices that we provide when we are doing a Zoom or a COVID type election where we're under modified procedures, we do a separate Q&A or FAQ to the membership explaining who's going to be there, how it's going to be conducted, what the difference is, to kind of reassure everybody of what the process is going to be if it's different than what they're ordinarily accustomed to.
Excellent.
Okay.
So as far as who's in the Zoom meetings, obviously this is changing as we move into the different phases. When we were under lockdown and we had to do this, we really needed to limit, at least here, to no more than 10 people in the room. And the recommendation that I always did was it would be the property manager, myself, and we'd solicit an impartial committee. So usually 2 counters, just to limit it. I would do 2 counters and myself, and everybody else would attend via Zoom. That was the way that we could limit this.
So I've had some associations that want to allow owners to come on a first come, first serve basis, as long as you have a procedure and you're still allowing for social distancing. And if the attorney and the manager and the people who are going to be counting are okay with having other people in the room, then I think that's okay. But I generally recommend that you don't allow special treatment for anybody. So if you're going to say we're holding the election via Zoom, only the attorney, manager, and counting volunteers will be allowed, then you don't allow anybody else. It just makes things go smoother so everybody's on the same position and watching from the same angles.
Correct. Yeah, our experience has been similar. I mean, we either have a combination of a hybrid where, you know, a couple people are at the property, and then most of the individuals are either on Zoom. That's been our experience. A lot of people are still very cautious. And at the end of the day, I believe also a lot of people just don't want to drag down. They want to understand what's going on without necessarily having to be there. So there's been some major advantages with the use of this technology. And also, it also depends how you set up your meeting, your Zoom meeting, because there are ways of setting it up similar as to what we do here with the webinars, where you have the board of directors as the face, as the panel of experts, and then have the rest of the residents in the background, but they still have the ability of providing comments and suggestions, and they still have the ability of seeing everything that's going on. So there's a lot of different ways that the process can be set up.
Okay, so next slide. Okay, so this is the big dilemma, right? We have the whole condo election via Zoom. We have that figured out and down to a T. But when it comes to HOA elections, we really do have a dilemma. It's helped a lot that now we're not under emergency order. So assuming that, and a lot of factors go into this. So I'm not going to be able to give you a solution because it depends on the type of association, how many units, whether or not your governing documents allow voting by proxy, whether you're required to take nominations from the floor. One thing to keep in mind is because with an HOA, you're not doing the 2-envelope process, and therefore your ballot doesn't necessarily count for quorum. You know, attendance via Zoom at an HOA meeting doesn't necessarily count for quorum unless you're able to provide a ballot. So it creates a lot of issues. And if you're able to find a way to address all of these issues and still run an effective election, then you can certainly do it via Zoom. And we have some suggestions. You can hold a meeting outside. You can establish timelines. So at this time, we're going to all gather outside and call for nominations, and then everyone can take a ballot and then submit the ballot at a certain time, and then we're going to count, and you can watch it via Zoom, and then you can come back in order to hear the results, or it will be announced via Zoom. For a while, we took the position that for HOAs, it would likely be better if you postpone your election, because we were under an emergency order from the governor because of the pandemic, but that is no longer the case. So if you're going to postpone, I'd be careful with doing it too far out after the 13 months from the last election. I'd consider looking at your documents and see if there's a way that you can adopt a different election procedure rather than the nominations from the floor, perhaps by virtue of a resolution. Or maybe you adopt a resolution where you allow nominations in advance. So there's a lot of strategies, and this is one issue that if you're from an HOA and you're due to have an election, it's definitely worth it to reach out to your legal counsel and have this discussion. It's important. It's important that your membership knows what you're doing. And if you've decided to postpone because of COVID, communication is really key. Let them know that you have concerns about holding the meeting. Maybe you don't have a location that can accommodate everyone socially distanced. So you physically and practically cannot hold the meeting if that's the case. But communicate, because that's going to be critical, and it's going to avoid so many issues moving forward.
Excellent. So before we switch gears here, Alessandra, I wanted to go through some questions that are popping up on the Q&A when it goes to elections before we go into budgets. There was one question here, I believe it was from Diana, with regards to how to select an impartial committee when you're going to tally the votes or the ballots that you received. What is your firm recommending if the associations are holding these meetings via Zoom and so forth?
So
So what we
go ahead, Carolina.
So it depends on the association. I mean, the best method under the circumstances would be to send out a general email communication to the membership saying, we are soliciting a volunteer, and identify what the criteria for being an impartial member is, and then take them on a first come, first served basis. The truth of the matter is, we usually have a harder time getting volunteers to count.
Yep,
so, you know, it's not something where everyone's going to be jumping up and down to spend, 2-3 hours of their time opening, sorting, and counting ballots. But communicate to everybody as to who wants to serve, and then make the decision.
Excellent. And I have another question here from Sandra that sent it over to us via email. And it says, can a president call an annual meeting when it suits him or her to get the new boards elected, to the new board? I think what she's asking is, does the president have the ability of scheduling when the annual meeting occurs?
So generally it's dictated by the governing documents. And if you look at your bylaws, it will generally say that it has to be done between January or March, or within 13 months from the last annual meeting. So it's not something that the president or any other director or officer should unilaterally be making that decision. You should work with your board and make sure that you work with management and attorneys to ensure that everyone's on the same page, especially if it's a condo election, since you have to plan 60 days in advance. I made the mistake because I didn't have certain things on my calendar, and given everything that's going on, I've scheduled annual elections on my son's birthday and on Yom Kippur.
It happens to the best of us.
So, you got to plan ahead. You got to have your calendar 60 days filled out so that you don't end up being a bad Jew or hated by your family.
Excellent. I have another question here from Samantha, and I think I should be able to address this one here. Samantha asked basically that she feels her elections have been done improperly because the manager gets involved in the election process. She specifically mentions that the manager is kind of helping throughout the process of getting votes and getting involved in that process. From a management perspective, I can answer this because I know from the way we educate our managers is our role isn't really to get involved in this process at all. We're supposed to just follow whatever the procedures are with the mailing of the notices, working with the team members such as the association's attorney in preparing all the necessary documentation, but actually going out and obtaining votes and getting members to vote on a particular board president. We need to stay very neutral on that. One of the things that we like to say here is we'll never know who our boss will be tomorrow. We could be dealing with a member that's the biggest pain in the butt, and tomorrow he becomes a president association. So we need to be very neutral. So your manager should not be getting involved in obtaining votes and going out and collecting ballots for that. At least that's our philosophy within our organization.
And the same thing goes for attorneys as far as unbiased. There's a lot of turnover, obviously, when a new board comes in, they want to wipe clean and get rid of everybody. And while we know it happens, just because you didn't like what the prior board did, doesn't necessarily mean that they were following the advice of the current attorney. So while we're at the election, we're attorneys, just like managers have licenses, we have licenses. We're going to be doing everything according to the law. I mean, at least you would hope, right? I know that at our firm, we understand that if a new board comes in, they may be bringing another attorney, but we're still going to do everything pursuant to the law regardless, because it's not worth our license. It's not worth an election dispute. And you want to make sure that, in this industry, our reputation goes a really long way. And, I'd like to say that goes for every attorney. I can't speak for everybody else, but I can speak to our attorneys, and that when we are attending an election and along with management, we're not making decisions based on who we want to be on the board because we're going to be retained or fired. That's just not how it works, even though I understand that that's a conception of usually the group coming in.
Of course. And I have one more from Tony. Could the property manager be the inspector of the election for the HOA?
We've done that before. A lot of times it's difficult to get unbiased individuals, especially during COVID. Right. So I prefer not to. Sometimes I ask the manager to bring in other people from the company or other colleagues if we can't get volunteers, because that way it's not the manager themselves, especially because usually we need the manager to help us identify owners and assist with the ballot verification process. So I don't want them to be in that seat. But I don't believe I know the statute talks about volunteers, and it says that they can't live with an owner, be a candidate, or live with a candidate or current board member, be related to, reside with, or be biased in any way. We take it a step further and say, generally when I have counters that are from the association, I'll even introduce them and say, does anyone have any objections to this individual being a counter? In order to ensure that we're not going to have people claiming after the fact that these were biased counters.
That's a great point. Carolina, I think you wanted to jump in as well.
Yeah, there's a couple of things that have been going on, but I just completely lost my train of thought with a different question. So keep going, and I'll jump in after.
No worries. So let's switch gears here. I'm sure, we're in the midst of already starting Q4 in the fourth quarter. A lot of budgets should be already prepared, or at least presented to your boards. Let's go over a little bit about budgeting during COVID-19.
Okay, so procedurally speaking, budget process does not change. The board of directors still required to adopt the budget every year before their fiscal calendar or calendar year, however it's defined in the governing documents, and it's based on the prior year's expenditures. You're still required to fully fund reserves unless they are properly waived by a vote of the membership, to either waive partially or fully, but it's really risky, and if you're one of our clients, we've probably discussed the waiving of reserves and the consequences, because then you end up having to specially assess, and you have to weigh the pros and cons of that. As far as COVID considerations, as a result of COVID, there's a lot of things that you should consider when you're adopting your budget. For instance, are you going to need additional staff? Are you going to need additional people to monitor the pool if you've reopened your pool? What happens if we go into lockdown again? Do you have, now that we know what it entails, do you have the resources and the funds to fund those resources available to continue operating your association as you wish maybe that you could have before, but you just didn't think ahead because this is all unprecedented. Additional cleaning expenditures that you've incurred this year, or maybe you want to adopt moving forward. The increase in delinquencies, which is, we're seeing a huge increase in foreclosures, delinquencies, and we expect that it's going to go up. So you might want to include that bad debt item in your budget and take that into consideration. You may even want to do a COVID reserve. And the other option also is an emergency line of credit. So some associations will take out a line of credit, and you have to look at your governing documents to see whether or not the board can approve a loan or whether you need membership approval. And you have to go through the procedures, but there are a lot of banks out there that will issue the loan. And at least you have that. You don't incur any costs or fees unless you draw the money. And when you adopt that line of credit, it will be based on emergency circumstances, and the board can define that. But given that we live in Florida and we're at risk of hurricanes and now pandemics and who knows what else, it's always a good idea to, whether if you don't have reserves, to make sure you have that line of credit lined up just in case, so you don't end up in a situation where you have to specially assess owners when everyone's already going through a really tough time because of the circumstances.
Yeah, and I'd like to add to that, because you bring up an excellent point with the line of credit. And if you're going to apply for it, now is the time. I mean, I know what we're seeing in the news is, that multifamily is doing well and so forth, but we're seeing a different picture. We are seeing us increases as we go. And I do believe, and I continue to say that we're in some form of a shadow market. We won't know what we're really going to be looking at until they lift all the moratoriums that are currently propping up everything that's going on. So now's the time to apply for that line of credit, because most likely your delinquencies are going to be in a position to allow you to get approved for that loan. If you wait too long to be able to get approved for that line of credit, then when you need it, you may not be able to, because your delinquencies are in a position that the bank won't allow that to occur.
That's a really good point.
Further, it's important that as board members, that you understand it's your fiduciary duty to uphold, the finances of the association. And while, listen, I get it, you're a nonprofit organization and you don't want to hurt the residents, it's important for you to forecast of what you believe what's going to happen with your association. So you should be working very closely with your accountant, with your management company, if you have one, to understand your current position. If you know some history of what happened during the last economical crisis, then you have an idea of what can potentially happen. And that way you're preparing. We've already started to present some budgets, and we're an organization that we're going to present you a real budget, and then we'll talk about it. And we're presenting some significant increases. And the reason is we want to be able to plan and be ready should something occur. Because if you don't, to try to make a change later, it's going to be much more difficult, and it may be too late.
So that's a really good point. And piggybacking on Rafael's comment is that you should have a collection procedure that you're actually enforcing. Correct. Don't wait until you're a year delinquent to send it to legal, because once it gets to us, there's a whole process that we have to go to before we can foreclose. You want to make sure that you have a procedure at 30 days, 60 days, it goes to legal, and then let us or your attorney start moving the file. You don't want to end up in a situation that there's so many delinquencies and now everything is in litigation. You can't get a loan. You're going to specially assess, but you have such a small percentage of owners that are actually paying that it's a huge burden on them. You want to plan ahead, just like with the line of credit, because of possible delinquencies. You want to make sure that you are addressing those delinquencies as they come up.
Okay, excellent. I have one question here that I think, since it's with the topic, is from Elizabeth. Is the treasurer or president allowed to prepare the budget without the other board members prior to any workshop meeting?
So this is, it is somewhat of a managerial, who prepares the budget, or somebody has to step up to the plate and prepare it. In some of our associations, I know Affinity, your managers actually take the first stab a lot of the times as to the budget. They provide that first stab to the board for review. Different associations structure their budgeting process different. So while a president or a treasurer can go ahead and step up to the plate and prepare the draft, that doesn't necessarily preclude other members of the board from making suggestions, reviewing, and commenting. The budget goes out, as you know, 14 days in advance of the budget meeting, but that budget can be amended by the board during that budget meeting. So I routinely, and I know I have one viewer, when we go to their budget meetings, you won't be named, but I know that this is a very diligent board, and even though they've gone through it many, many times, at the actual board meeting, they go line item by line item. They review and they have discussions, and there's changes that are done. So it's a fluid document, and up until the time that the board of directors votes to adopt that budget, everyone has the right to everyone on the board has the right to make those changes, and obviously input from unit owners is obviously considered at that meeting, whether or not the board decides to implement it.
And if I can add to that, it's also important with the workshop, right? Because that word gets thrown around all the time. If you're going to have a quorum, it's technically a board meeting, so you do have to notice that meeting. You know, we get asked many times, oh, we want to discuss it between us first. We can do that as long as there's not a quorum. However, if there is a quorum, you do have to go through the proper noticing requirements that the statute requires. So
one other clarification, Rafael. We got a question about HOA reserves, and just to clarify, HOAs are only required to fund the reserves if they're developer imposed statutory reserves, and there's a distinction. So definitely speak with your attorney and accountant in regards to HOA reserves. Sometimes it's unclear because the association has been doing it haphazardly for so many years, but it's definitely something you want to look into. It's not a bad idea to have those reserves, but in HOAs, it's not required like it is in a condo. And then another question, and just to clarify, I think I said earlier that we are not under emergency order, but it appears that we may be with some changes until November 4th. So my apologies for misspeaking, but I still think that you need to be cautious with how you act. November 3rd, I think, is when that order expires. If there haven't been any subsequent orders that retract it. But then again, this is such a mess with these orders, guys, that we always constantly are looking it up to confirm. So who knows what's going to happen in the next week.
Somebody else asked whether a property manager can solicit proxies to get a quorum. In the condo setting, there's nothing wrong with that. I mean, a lot of the time we want to get, they're not soliciting the ballots, they're soliciting the proxies. We want to get participation. We want to encourage participation. So there is nothing wrong with encouraging your membership to participate and to have a proxy in order to actually have your meeting. So nothing wrong with that.
Correct, and I would agree with you there, Carolina. We do get asked for that part for the proxy in order to get participation, and there we do get very involved, especially with the couple associations where they need those proxies to vote down the reserves. It's not something that we want to do, but we do assist in that process. So yes, I would agree with you that is common practice. So we have.
So now we.
All right, go ahead.
So now we are going to move on to electronic voting. Unless you guys wanted to touch any other topics beforehand. No, we're good. All right. So we've actually, electronic voting has been around for a few years. However, it's not something that's been tried and tested through the court system, okay? I think that there are a lot of misconceptions about what electronic voting is, how it works, and how it's done. And very little to no guidance from the division or the courts as to the glitches that we've all faced. And I think that with COVID, we definitely saw some glitches with the electronic voting process. That being said, if it's properly implemented, it's a valuable tool because it not only, it opens up your ability to have so much more participation. I mean, I can't speak enough of that. Condos, HOAs, and co-ops are are permitted to utilize internet-based voting systems. However, it's not just, let's get on Zoom and everybody click raise your hand or let's take a poll for voting. That's not how it works, people. You have to meet specific requirements under the statute. And once you have implemented that, you can, but are not required to use it for your elections, meetings where you're voting on amendments, meetings where you're looking to waive reserves. So it's a very useful tool. It's not mandatory, nor is it mandatory for unit owners. So once an association adopts it, the unit owner has the power to determine whether or not they want to use electronic voting. It's not something that you can impose on everybody. And unit owners have the ability to opt out of electronic voting.
So something to consider with electronic voting, Carolina mentioned that there are specific procedures. One of the main things is that the board can adopt electronic voting, but it needs to be done with a 14-day notice and with a copy of resolutions and all these statutory requirements. So when you're thinking about planning your election, and if you've already started the process, you really shouldn't be implementing electronic voting now. It's very confusing, but generally, you're required to put on your notices that you're doing electronic voting. So when you think about it, now you're 75 days in advance if you want to first adopt electronic voting and then send out your first notice so that you have proper timing to do everything. So if you're going to do electronic voting before an election, try to do it ahead of time so that you have all the kinks figured out, so that you can upload all the membership information, so that you give everyone the opportunity to opt in and opt out. One of the main, we have a lot of considerations when utilizing electronic voting. As Carolina said, you know, a lot of it hasn't been decided by the arbitrators or by judges. So there's still a lot of questions out there. The statute has a lot of requirements, being able to authenticate the owners and keep the voting anonymous. There's an administrative code that goes along with the statute that imposes additional requirements. The polls have to close in a condo election when you open the first outer envelope, just like when we're doing paper ballots and we announce, okay, the balloting is closed. That's when your electronic vote needs to close as well. You have to give enough time for individuals to opt in and submit their decision in writing. You have to comply with the resolution and the deadlines adopted by the resolution. The deadlines adopted by the association in the resolution. And the votes done electronically count towards quorum. So that's great because it does allow you to get quorum by virtue of an electronic vote. It's important to make sure that your voting certificates actually match the opt-in and opt-out forms. So we know that a lot of electronic voting providers like to have the opt-in be done electronically through their online system, but we also recommend that you require an actual form so that if you have an election monitor, they can go and look at those opt-in forms. Is that really signed by the individual that's authorized to sign for that association? And that's a step that's, you know, often that's missed in the process. Lastly, this is something that I'm not sure that every electronic vendor can do, but the statute says that once you submit a ballot, you can't take it back, right? So it's really important to know which ballot is going to count. If someone has the option to vote electronically, but they're also receiving a ballot in the mail, and a lot of times people get confused, they forget, they don't know when they voted, who they voted for, and then they vote again. And now you're dealing with an electronic vote and a paper ballot. And in a normal election, if you have two paper ballots from the same individual, you disqualify them. I like to err on the side of trying to get as many votes as possible. So what we've been trying to do is if the vendor's able to provide us a date and time of when an electronic vote was made, and if we have the property manager or whoever's receiving those ballots keep track of when they're received by the association, then we can determine whether the electronic vote or the paper ballot was received first. Other associations take the position that the electronic always supersedes over the paper ballot, and that's in their resolution. So something to consider and to be aware of when you're looking at vendors.
Well, those are great points that you bring up. So next we go into the Q&A. So I'm gonna go over some questions here that we have between the Q&A in our box, as well as questions that were emailed to us. One particular question that I have here that I believe I can answer is from Frederick. It says, with pooled reserves, how do you determine the annual reserve contribution? If the proposed budget includes a smaller contribution, is an owner's waiver vote always required? So number one, the statute, Frederick, basically states that there's 4 items that must be included within the reserve schedule that you're presenting to the association, even if it is pooled. Determining what the figure is, there's multiple ways of doing it. The best way of doing it is, number one, is having a reserve study in hand that an organization, that a company does by a professional engineer. And that reserve study will give you a determination of what the useful life and what the potential cost for those items will be. And that's going to get you as close as possible. If your association doesn't have the necessary funds to do a report like that, even though honestly the report is very cheap in comparison for the value that you receive, then you would use those 4 factors and you would use your best estimate based on your estimated useful life. Correct me if I'm wrong, Alessandra or Carolina, there's nothing within the statute that regulates specifically of who can determine those figures. The statute really talks about 4 major items that must be included within those reserves.
And I do believe for condos, it says that you should have a reserve study every certain amount of years and that the budget should be based on that. I don't think it's a violation if you don't, but then you're kind of arbitrarily coming up with numbers, which is arguably not in line with your fiduciary duty to act in the best interest of the association. So it all goes back to reasonableness and best interest of the association when it comes to budgeting.
So I want to ask you this question. We were just chit-chatting about this the other day with my manager. So if you do obtain a reserve study, right, and it gives you, it's done by a professional, it gives you, okay, you have to, for round numbers, $100,000 is what you need to put away a year. The board doesn't agree with that reserve study, says no, that those guys are exaggerating. They want to reserve $70,000. We were having the discussion, does this mean that now they're partially funding the reserve because technically they've received the reserve study? You know, we're kind of taking the position, yes, but, you know, they're arguing no. What's your take on that point?
Well, so the reserve study is just that, it's a study, right? Yeah. So I see where you're going with it as far as, well, they have a professional telling them it's going to cost 100,000, but they want to do 70, so they're partially funding. But in essence, they determine what the replacement value is and how much needs to be funded. So I think the board does have some discretion there, but it doesn't mean it's not going to backfire, right?
And ultimately, to put this in perspective, if you do get the opinion of a qualified engineer indicating that the replacement value is $100,000, and for whatever reason the board does choose to fund it at $70,000, the risk there is that when you do have to replace it, you really won't have enough money in your kitty to replace it, and that just leads to a special assessment. So it's always a battle with trying to get, nobody likes reserves. Nobody likes the concept of reserve. But you know what? If you think about reserves as your 401k for the association or your rainy day fund, that's what it's there for. It's there so you plan ahead because you know that your roof will need to be replaced within X number of years. So by the time that time comes around, there you go. You have the money and you don't have to scramble to specially assess your association because the money is there. So it's like pay now or pay later. That's the way I look at it.
Excellent. Well, we're up to our 1 hour mark. Before we close, I did want to announce that I know Eisinger Law is doing a free virtual board certification. So if you're interested, feel free to email Joshua, which we have included his email address here. It's going to be on October 14th. Before we wrap up, Carolina or Alessandra, do you have any final words for our listeners?
Just hang on tight, guys, and stay strong. It's a difficult time for everybody, especially those of you guys that are volunteering on your board. There's a lot of unknowns, you know, unanswered questions, and we know that everyone's trying to do the best they can. So, you know, utilize your professionals, reach out to your management company, your attorneys, and have them help guide us through elections and budgets and everything else during COVID and pandemic. And just generally, you're going to be better off if you have the advice of the professionals. And thank you guys for taking the time to attend.
Thank you, Alessandra. Carolina?
Thank you so much for joining us today. I guess I would ask all of you if you would please give us a review on the course or give us some Google reviews so that the more positive reviews we have, the more that we can encourage having more of these webinars as we go along the way. But I think Alessandra summed it up. You guys are volunteers and you're doing a fabulous job just by trying to keep yourself informed of the current topics affecting your association.
Thank you, Carolina. And first, I wanted to again thank the dynamic duo here, Carolina and Alessandra, for allowing me to do a webinar with the both of you. I also wanted to thank the team behind the scenes that helped put this together. As both Carolina and Alessandra mentioned, just hang in there. I mean, we're going to get through this. Ultimately, it's very important that you work with your partners. We try to compact all the information that we have into 1 hour, but sometimes it's impossible. So it's important that you reach out to your attorneys and your management companies to help you guide you, I should say, through this process. If you need to reach any of us, I'm sure I could speak for the ladies that will be glad to help you in any way. Feel free to reach out to us. Again, the video will be posted on both organizations' website. And we want to thank you and hope you have a wonderful week.
Thank you. And thank you, Rafael and Affinity, for doing this. We love partnering with you guys.
Being here. Thank you. Have a great day.
Thanks.
Bye, guys.
Bye.